Happy Wednesday. Hope you are all doing well. We have plenty to talk about tonight. We had a surprise live twice in a row, so we'll have some updates on those things. And then there have been just a lot of small things that have happened in a lot of cases that you all are interested in. So I'm looking forward to talking about those things as well. Welcome. My name is Lori Hellis. I'm a retired criminal attorney writing a book about the Daybell case, which you can see the cover right there. It's so weird that the projection's backwards because I never can figure out which finger to point at. But you can see the draft cover is down on the left-hand corner there. And welcome to everyone. I've been covering the Daybell case since before the children's bodies were found, since the children were missing and Lori had disappeared into the wilds of Hawaii. And so we've all been together watching this case for a while now. But we have a lot of other true crime cases that you've been interested in and asked me about and asked me to comment on. And so I thought I'd just do a little bit of a roundup on a few cases that we've talked about previously. And so I thought we would start out with Austin Ford. Now, this was a case out of Georgia. And recently, let me see, it was in September, I believe, the second mistrial was declared in that case. So the case was a case where he had been accused of murdering a friend, a female friend. And he had been, there had been two trials, and both of them ended in a mistrial. The most recent trial, the medical examiner, when he was asked, said he could not confirm, he could not rule out. Austin had always said that that he did not cause his friend's death, that she committed suicide. And the medical examiner said he couldn't rule out that possibility or determine whether or not the case was a suicide or homicide. And that resulted in the second hung jury. The jury did, however, come back with guilty findings on some other lesser charges against Austin. And so recently, the prosecutor in the case decided not to retry Austin a third time, and he was sentenced to 10 years in prison on the lesser charges. So, so that case has been wrapped up, but it was very interesting. If you recall, we also were waiting for a retrial on the Y.N.W. Melly case, which was also a hung jury. And so it'll be interesting to see how that works out. It's not that typical for prosecutors to decide not to retry a case after a hung jury. Y'all asked me what was going on in Corey Richens, so I thought I'd give you an update on that one. The most recent development is that the medical examiner found an antipsychotic drug in her husband, as well as the fentanyl. We saw the medical examiner's report identifying an antipsychotic drug, and it is a drug that Corey Richens was prescribed. So it appears that in addition to the fentanyl that she got from her housekeeper and gave him in a drink, she may have also tried poisoning him with her own prescription medications. That's what's alleged. Now, where are we at in the case? Corey Richens, on a couple of different occasions, has sent her lawyer what she called legal mail. And there were some concerns early on about the fact that she was sending letters to her brother and her mother, asking them to lie and asking them to create alibis for her. She was asking her brother to testify that her husband had been going to Mexico to get drugs, making up a lot of stories. And some of that information, there was some discussion about whether or not that information was covered by attorney-client privilege. So she recently sent a large envelope of papers marked legal mail to her attorney. The prosecution believes that there's evidence in that envelope and they want it reviewed. So the judge has appointed an independent attorney, an independent former prosecutor, to review that information and to inform the judge of whether the information actually is attorney-client privilege material or whether there is information that Corey Richens is trying to hide by getting it out to her lawyer. So that review is still underway, and so no trial date has been set at this point for Corey Richens. A little bit of an update on the Heuermann case. I'm going to save the Adelson case till later because we are going to talk at length about conflict and attorney ethics, and so I want to save that one for a little while. Likewise, I'm going to save the Vallow case for a little bit. So in the Heuermann case, Rex Heuermann is the man who has been accused of being the Long Island serial killer. He is in custody. No trial dates have been set yet. And he was charged. The indictment in his case was a new superseding indictment was filed. Superseding meaning takes the place of a more current indictment, which also charged him with the death of Maureen Brainerd Barnes. She was the fourth victim that was within the group of victims that they were investigating. They did determine that, like the other victims, Heuermann's wife's hair was on Maureen Brainerd Barnes' body. Now, that does not indicate, as we've talked at length about in the Lori Vallow case, where Lori Vallow's hair was found in the tape on JJ's body. It doesn't indicate that Asa was at all involved in the case. It only means that hair gets shed, and if the victim was in a location where Heuermann's wife also was, there could be hair transferred. So it identifies that that the body was somehow connected to Rex Heuermann's home or his vehicle, but it doesn't necessarily indicate any involvement on her part. And in fact, the prosecution has very clearly said that on all of the potential murder dates, she was at least out of state, if not out of the country. So I think a lot of people have been quick to jump to some conclusions about her. And I don't think we really have enough evidence or enough information in any way to jump to those conclusions. So we talked at length about the Murdoch case and about what's been going on with it and about Justice Toll. And I think in a lot of ways, that case has turned out to be one of those be careful what you ask for, you might get it instances, because I think that doing their best to get Judge Newman off the case backfired, because they got an inassailable judge in Judge Toll. I mean, there is just nothing that you can argue about Judge Toll. She is known to be a legal scholar. She is known to, she's experienced. She's the former Chief Justice of the South Carolina Supreme Court. She's 80 years old. She is absolutely as bulletproof as you could possibly be. And I think that is that's really hurt Pootie and the Grifter, because she has been very clear that she is going to limit the evidence that's going to come in at the evidentiary hearing, and that evidentiary hearing is going to happen on Monday next week. So I'm really anxious to watch that and to see what she does, because I find her fascinating. She is very no nonsense, very straightforward, very transparent. I mean, from the very beginning, she very much was putting out there and really transmitting early on what her expectations were and what she was and wasn't going to do about the case. So really interesting, and I'm looking forward to hearing that next week on Monday. Y'all asked me about Suzanne Morphew. You may remember Suzanne Morphew disappeared from her home about 3 years ago. And her husband, Barry Morphew, was charged with her murder based on some pretty thin kinds of accusations. He then, his attorneys filed lots of motions trying to get discovery, trying to get a lot of other things. And it turned out that the prosecution had violated all of the discovery rules, and they ultimately dismissed the case against him. This September, her remains were located after all this time in an area where other bodies had been located and where law enforcement were actually looking for someone else. And now it's been announced that the professional responsibility organization, the Colorado Bar, is investigating the prosecutor for misconduct. So that's never good. And if I had to guess, I don't know that Barry Morphew is ever going to be prosecuted. We don't know whether he was involved in her disappearance and her death. We don't know. But there's certainly, at this point, the evidence has not been produced to show that he was. And so I think I don't know that we're ever going to see that prosecution happen. And just a couple of other brief updates. We have Bryan Kohberger, and things are kind of stalled in the Kohberger case. Once again, we have a judge who has been ordering that things be reviewed in chambers before they're released. So, sorry, runny nose. One of the things that they did was that the prosecution resisted it very, very vigorously, resisted turning over all of the genetic genealogy information to the defense. And the judge, after having reviewed all of that stuff in chambers, determined that quite a bit of that genetic genealogy information was to be turned over to the defense. So they've received that, or the judge has ordered that they receive it. In the meantime, the defense is also challenged, which is very common in death penalty cases. We've seen it in several other cases, including Daybell, where the defense begins by attacking the underlying process, the grand jury, the indictment, all of the foundational pieces, because what the rules of criminal procedure say, if you don't bring the challenge, it's waived. So defense attorneys don't want to waive those opportunities to make sure that the prosecution has dotted all their I's and crossed all their T's. At this point, there doesn't seem to be any indication that there was any misconduct or any problem with the grand jury, but the judge has ordered that there will be a closed hearing, and that is very common. We saw it in Vallow as well. Anytime that there are discussions about the grand jury, because grand jury proceedings are secret, and so anytime the grand jury is being looked at, whether the panel was properly vetted, whether there was prejudice or bias on the panel, whether there were errors in the material that was submitted to them, whatever it is, that's all done behind closed doors. So not surprising that we're seeing that hearing go forward. I think it is in about 2 weeks that they're going to have that closed door hearing. The prosecution filed a motion asking the court to set a trial date, and specifically asking the court to set a trial date this summer, in the summer of 2024. One of the things they said was, Moscow is a very small community. The high school, the high school for, as far as I know, the only high school, is right downtown, right next to the courthouse. And we also have a huge influx of students and people visiting students when the college semesters are in session, because University of Idaho is there. So they're asking that whatever the court does, that they set the trial dates for a time when school's not in session, so that it doesn't put additional pressure on that downtown core, on parking, as well as not putting additional pressure on hotels and those sorts of things. So I highly doubt that we will see a trial this summer. That's far too compressed to get to a death penalty trial. But I would not be surprised to see the court set it for next summer. So I think we're probably a year out from a trial in that case. You also asked me about Lindsay Shiver. She's the woman who was being held in the Bahamas and recently was released on an ankle bracelet and allowed to go back to the US over the Christmas holiday. Her next hearing is the 31st of January. We don't know whether that hearing could be held remotely or whether she will be required to be back in Nassau for that hearing. Her trial is set for March of 2024. And because this is a trial that's happening in a foreign country, we don't have any information about whether that trial might be live streamed, whether we might see any of it. I sort of doubt it, because they are very much more in the vein of British jurisprudence. So I sort of doubt they will stream that trial or allow cameras, but that it remains to be seen. So I do want to talk a little bit about Vallow Daybell for those of you who may not have caught our surprise live last week. Chad Daybell's attorney filed a motion to be. Oh, you'd think I'd rented these lips. Chad Daybell filed a motion to withdraw from his case and have Chad appointed to uh, death penalty qualified attorneys. Now, if you want a full description of death penalty qualified versus not death penalty qualified and all of that, go back and watch that, because I know you all still have questions about how John Pryor can represent Chad Daybell when he's not death penalty qualified and Chad's been charged with the death penalty. So in a case where a person retains their own lawyer, they are responsible solely to decide whether their lawyer is qualified to represent them in the particular case. And Chad Daybell hired John Pryor. Now, we knew from very early on that this case was going to be a death penalty case. As soon as the indictments were filed after the children's bodies were found, as soon as the children's bodies were found, it was almost a year before the murder charges were filed because of COVID and not being able to convene a grand jury. But as soon as the indictments were filed, we knew that those cases were going to be death penalty cases. So it's no shock to John Pryor that that his client has been charged with the death penalty for 3 years. And it's no shock to Chad Daybell that John Pryor was not state death penalty certified. So everybody knew all of that. However, when a lawyer is appointed and paid for by the state has the right to set qualification guidelines. So in any public defender case, the public defender must be qualified. And that starts out with doing misdemeanors, and then you get qualified to do felonies, and then you get qualified to do complex felonies. And then if you choose, you can apply to be death penalty qualified. So death penalty cases are very different, and they're defended very differently. And so it's important that the lawyers understand and the state understands, because when the state's paying the lawyer, they now assume liability for making sure that that lawyer is fully qualified. So the state has requirements. Those requirements only apply if the attorney is court appointed. They are not required if the attorney is retained, like John Pryor. So John Pryor filed a motion to be allowed to withdraw, and because he said Chad Daybell is indigent, Chad Daybell the judge had found that Chad Daybell was indigent in a sealed order from last January. The judge recently unsealed, as part of the hearing that we just had, unsealed those documents so that the public could see that, in fact, he had found that Chad was indigent a year ago. So they had a hearing, and it's a mystifying hearing. It's up on East Idaho News YouTube channel if you want to go watch it. It's very strange. John Pryor starts out by asking to withdraw. Then he says, I don't really want to withdraw, but that's the only way that Chad can get qualified counsel. And oh, by the way, he's going to need another year before he goes to trial. And ultimately what Judge Boyce said was, Mr. Pryor, you assured me a year ago that you were in this for the long haul and you were not going to be withdrawing. And so the answer is no. So he did not allow John Pryor to withdraw. John Pryor is not getting paid, but there certainly is precedent for a judge saying, I'm really sorry, but I'm not going to let you off this case, because to do so would cause prejudice to your client. And there is a disciplinary rule that is right on point that says that you cannot do anything that will compromise compromise your client, particularly in a criminal case where your client has due process rights. So Chad Daybell stayed on, and the judge has just said, nope, not going to do it. It was surprising because I felt, because it was a death penalty case, that it was likely the judge was going to hold his nose and allow Pryor to withdraw. And but Judge Boyce made some persuasive arguments and decided that he was going to leave him on, and the April 3rd trial is going to continue. That's great for me because I'm going to finish a couple of updated chapters, and now my book can come out on time as it is supposed to. But in the meantime, Chad and his attorney are scrambling to try and get experts lined up to try and get and to try and get ready for a death penalty trial. The other thing that was interesting was that Judge Boyce asked Mr. Pryor if he had hired a mitigation specialist. And he said, I don't want to talk about that in open court. I don't want to talk about it in front of the prosecution, but I'm happy to answer those questions in chambers. So not only did they have an in-chamber session, but he also had an ex parte session, meaning the other side wasn't there, in which he talked to the judge. When the judge came back out, he didn't say one way or the other, but he did say, I acknowledge that because you are retained counsel, you are not obligated to follow the American Bar Association's best practices for death penalty cases, which would include hiring a mitigation specialist. So, which pretty much telegraphed that he has not hired a mitigation specialist, which is that's pretty serious. I can't imagine. I mean, the only thing I can imagine is that he feels at this point like, that Chad feels at this point like he's going to be found not guilty, and so he doesn't need a mitigation specialist. It's pretty crazy. So it will be pretty interesting to see how that goes forward in April, but it appears that for better or worse, they're going to trial. So, and I want to talk about Adelson because some came up in Adelson, and I thought y'all might like a little bit of a deep dive into it. So Charlie Adelson is still at in the reception unit for Florida Department of Corrections because they've not been able to identify a bed for him in the special protection unit, and so he is still in the reception unit at this point. So what happens anytime anyone is sent to prison is that they very first go for about the first 30 days into a receiving unit. And what they do there is they sort of orient people to how, the rules in prison and how to survive and all of those things. They also do mental health evaluations and a lot of other sort of screenings and those sort of things in order to decide where to place them. In Charlie's case, it's very clear that he needs to be in a protective unit because of the high visibility of the case, the fact that one of the gunmen is a Latin King, which is a Florida gang. And so I think it is taking them additional time to secure a place for him in a special protection unit. Now, Donna Adelson is still being held in the Tallahassee jail. She was recently moved to general population, so she was recently allowed out of the mental health holds but the most interesting thing that happened recently if you recall, if you followed Charlie's trial, his lead attorney's name is Dan Rashbaum. Now, Dan Rashbaum has been a friend of the Adelson family for some time. He was involved early on. He's been involved with them since the first suspicions were raised about the Adelson family years ago. So he has a long relationship with the Adelson family. He had previously represented Donna and Harvey. Charlie had to sign a waiver of any conflict in order for Dan Rashbaum to represent him. Charlie was tried. Dan Rashbaum represented him at trial. He went through trial. He was convicted and sentenced. And now Donna Adelson, Charlie's mother, has been arrested and is being held in a Tallahassee jail. She originally had a different attorney down from Miami. Her name was Marisol. She withdrew, and Dan Rashbaum and a local Tallahassee lawyer have substituted in. So Donna had a hearing earlier this week, and at that hearing, it was supposed to be a status and trial scheduling hearing. And it's unusual for clients to appear at those hearings, particularly if it's pretrial, and it's very, unless there is something to be done directly with the defendant, such as arraignment or advising of rights, any of those things, usually they don't appear. So everyone was a little surprised when Donna appeared by Zoom. She appeared by conference call from the Tallahassee jail. So this is what happened. The judge wanted her, because he wanted to question her about attorney-client conflicts and whether or not she was waiving them. Now, there are some attorney conflicts that are not waiverable. And I don't want to really go into those right now, but we're going to talk about what happens when attorneys can waive their rights. So what I did, most of the state professional responsibility rules have been adopted from the Model American Bar Association rules, and Florida is no exception. So I want to talk a little bit about the rules. And much as I hate reading to people, I do want to read these. This is conflict in a client-lawyer relationship. So it says, except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to the affected client. The representation is not prohibited by law. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or another proceeding before the tribunal, and each affected client gives informed consent confirmed in writing. Okay, so that is a conflict with your present client. So that's Donna. So now let's take a look at former client relationship. A lawyer who has formerly represented a client in a matter, then hereafter represents another person in the same or substantially related matter in which the person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. So it's very clear that you cannot represent someone whose interests are materially adverse to another client, about whom the client lawyer has acquired information protected by rules 1.6 and 1.9c that is material to the matter, unless the former client has given informed consent confirmed in writing. So a lawyer who has formerly represented a client in a matter, or whose present or former law firm has formerly represented a client in a matter, shall not thereafter use information relating to the representation to the disadvantage of the former client, except as those rules would permit or require with respect to a client, or when the information has become generally known, or reveal information relating to the representation except as these rules would permit or require with respect to the client. I know that sounds like a lot of this is these and therefores. But the bottom line is, if a lawyer represents a client and they have an attorney-client relationship with that client, as Dan Roshbaum has with Charlie, he cannot use any information that he may have received through his representation of Charlie against Donna or to help Donna. And all clients need to understand that you have two people who are adverse to one another, meaning that at some point, Donna could throw Charlie under the bus. Donna could say, yes, Charlie told me all these things and I took him the money and it's all true. If she were to do that, Dan Roshbaum would be in a really difficult position of having to pick one client over another. So the requirement is that conflict be waived. So while we were watching her hearing, the judge specifically on the record wanted to question her and inquire about whether or not she understood the consequences of what she was doing. She assured the judge that she did, and Dan Roshbaum told the court that he had received in writing, confirmed in writing, both her waiver and Charlie's waiver. Now, Dan Roshbaum said, I no longer represent Charlie. He is represented by a very able appellate lawyer. But I still think that this is dangerous ground. And it's very difficult when you establish a relationship with a client and there is that trust that you have, that your client has for you. It's very difficult to turn away from that client and say, I can't represent you. It's hard. It's hard for the client. It's hard for the lawyer who really wants to do a good job for their client. It's really difficult. But sometimes it is the best choice, because I don't see any way that Dan Roshbaum doesn't get into the situation where he has to pit he has to pit Donna against Charlie. It's going to be really hard to dance on that tightrope. It's also really interesting that Dan Rushbaum reached out to Joe Waldman at Surviving the Survivor and asked to come on his podcast. Following that, he also did some interviews with some of the more mainstream media like Dateline. That also is very irregular, very inadvisable for an attorney to go at public and do interviews while their client is pending charges before trial. So very inadvisable on Dan Rushbaum's part. It was interesting that he tried very hard to toe the line, the ethical line, during those interviews. But it also was interesting that he freely admitted that he's very fond of Donna, that in some way perhaps she reminds him a little of his mom, and that he has a genuine fondness for her. Lawyers, I mean, we're all human, and sometimes we do develop a real fondness for our clients. I can identify a few that I became very fond of. And the longer you work with a client, the more likely it is that you are going to form a more personal relationship. Now, that's not to say that you're inviting them over for dinner and that they're showing up to be godparent for your child. Most lawyers don't really cross those boundaries. But in that attorney-client relationship, it is not all that surprising for an attorney to become attached to their clients that they're working with. Dan Rushbaum said he talks to Donna every day on the phone. And if that's the case, you're certainly going to form those kind of attachments. So I understand that he feels a sense of obligation to Wendy and to Donna and her family, to Charlie and to Donna and Harvey. And I think that it's unfortunate on his part, because I think it may, I won't say that it has caused him to go a little blind when it comes to his ethical obligations, because I don't think that's the case at all. I sure haven't seen it. I watched the interview he did with Joel. I haven't seen that. But I do think that the lines are more blurred than they should be. And I think that should raise concerns for any ethical lawyer. And I'm sure that Dan Rushbaum has given this a great deal of thought and has thought about it in depth before making these decisions. But nonetheless, I think that he is sort of treading on ground that might be a little dangerous. So it will be interesting to see, as things go along, the role that he and the co-counsel will continue to take, because he does have a co-counsel from Tallahassee. That was a smart move this time. Last time they did not do that. And in fact, they brought in a New York jury consultant. And Miami and Tallahassee are very, very different, which is one of the reasons why Wendy Adelson couldn't wait to get out of there. Tallahassee is up north, a lot more rednecks, a lot more country, a lot more rural areas, a lot more of rural Florida, and a lot less money, a lot less of the hoi polloi. South Beach, there's a lot of money, there's a lot of rich people, there's a lot of it's just a completely different environment. And I think that they made a tactical error in bringing in outsiders to try the case. And I think that they're trying, Dan Rushbaum is trying to remedy that now by bringing in a local Tallahassee attorney who is well known, who's tried a lot of murder cases and is quite well known and very well thought of. So real experienced, and so I think as we go along, if we are seeing places where Dan Rushbaum is running into barriers because of his ethical obligations, I think we're going to see more and more of that pass off to the Tallahassee attorney, because that would make some sense for Dan Rushbaum to stay on, because he's the one who has the relationship with the client, with Donna, but to also defer more to this Tallahassee lawyer when it comes to kind of walling himself off from some of the ethical considerations. So that is a little bit of a discussion about ethics and about lawyer conflicts. And I've run through all the things that I wanted to talk about, so I think it's time to take some questions. So I do want to remind everybody, while Jen is pulling up questions for us, Michelle and I are no longer working together, and Michelle is available, is easily findable on Facebook with her group 50 Shades of Guilty. And I'm sure that she would love to hear from you folks if you would like. We have turned off super chats because I did not want to continue to have to account for donations for Michelle now that she's not with us. So we've turned off those donations. Everything that has been donated to date will go directly to Michelle. And at some point, we'll probably turn our super chats back on. But for now, it just seemed like a cleaner way to make a break. So you might look for them maybe the first part of February. I also wanted to remind everybody, wristbands are still available. Justice for JJ and Tylee wristbands are still available. You can get those by sending a stamped, self-addressed stamped envelope to the address, which is in our show notes. And I would be happy to send you one. There's no charge, just the cost of a stamp. Well, 2 stamps, because you got to mail me. And I think that as we approach Chad's trial, it will be very important for us I really want to see us fill social media with photographs of people wearing those wristbands during the trial to show your solidarity and your support for the families of the victims. So, with that, we'll take, we didn't talk about Delphi, didn't we? I skipped Delphi, and Delphi is a big deal. I don't know what I was thinking, but you're right. Let's talk about Delphi before we take questions. Thank you, Jen. So very interesting. Last week, the Indiana Supreme Court heard arguments. Let me drop back and just do a quick little thumbnail of where we are at on Delphi. Richard Allen was arrested in this case, accused of having murdered 2 young girls who were out for a hike on a February day in 2014. So, no, 16, sorry, was the 14th of February, 2016. The girls went missing, their bodies were found, and years later, Richard Allen was arrested and accused of the crime. His attorneys, Baldwin and Rosie, have been absolutely convinced of his innocence and have been fighting very hard to make a case for his innocence. One of the things that came up early on was the fact that his attorneys believed that the sheriff, the law enforcement members from the sheriff's department who wrote the original probable cause affidavits were gave the court incorrect information and omitted information that the court should have had before making a probable cause determination. And so they filed a motion for what's called a Franks hearing, which is a hearing to challenge the underlying probable cause for the arrest warrant and all of the search warrants. It was a 139-page motion. It was filed last October, and it outlined in very painful detail their theory of the case. Their theory of the case is that a group of religious people in a religious cult, I assume that's what we'd call it, a group of people who worship Norse gods, including Odin, were responsible for the murders, and that they were done in a religious ritual, and that Richard Allen had nothing to do with them, that they were committed by people involved in this cult. The interesting thing about it is that this particular religious, I don't know if you would call it a cult, because it is a religious organization. There are people who practice Norse religions, who believe in Norse religions, and there are sects throughout the country, or really throughout the world, who venerate and worship the Norse pagan gods, including a god called Odin, who sort of is the god over gods. The interesting thing is that this is a religion that has been adopted by a lot of white supremacist organizations within the state prison systems. So in a lot of state prison systems, they have recognized Odinism as a form of worship and allow inmates to hold Odinistic worship services. In the prison where Richard Allen is being held, two of the guards who were primarily responsible for his management and overseeing him while he was in the prison were wearing "In Odin We Trust" patches on their uniforms. And there was some deep concern that there is some overlap between law enforcement and this Odinist religion and what potentially could have been the murderers in the Delphi case. So they, Baldwin and Rosie is how he pronounces it, Richard Allen's attorneys filed this motion. Judge Frances Gull, who is a special judge, was appointed to the case. She's actually a retired judge. She's a senior judge. She was appointed to the case, was furious because she had signed a gag order not allowing any of the details of the crimes to be released. And in this motion, Rosie and Baldwin outlined a great many things from the crime scene to prove that that the crime scene was staged by Odinists. And because their contention was that there were Odinist symbols that were left at the crime scene. So Judge Gull was very unhappy about that because she felt that it violated her gag order. And then in a completely unrelated incident, one of the two attorneys had the information out in their conference room, all of the discovery out in their conference room because they were preparing for depositions. And an outsider who had previously shared office space with the attorney came in to visit with the attorney. He was on the phone. While the attorney was on the phone, this person went into the conference room and took photographs of some of the photos that were lying out on the tables. he then disseminated some of those photographs. He has been charged criminally and taken full responsibility for that, and been very clear that nobody gave him that information, that he went in and stole it. But that was sort of the bitter end for Judge Gull. And so she called the two attorneys into her chambers, and in a chamber, I won't even call it a hearing, but a conversation that was recorded and there is a transcript of, she very clearly says to them, either you withdraw or I'm going to go out there and I am going to make public all of your poor performance, because I believe this was gross negligence. And they're backed into a corner. One of the lawyers says, all right, I'll withdraw. The other one says, I'll file a written motion, but then later doesn't. And she summarily takes them off the case and accuses them of gross negligence, tells Richard Allen that Richard Allen isn't even there. He's not present. So he doesn't even get a say in what's going on. There's no evidentiary hearing. She just unilaterally says, you're off the case. So they then file, she then appoints two lawyers from her jurisdiction who she knows, and to represent Richard Allen. So the two lawyers then file an appearance saying, we want, Richard Allen still wants us. We'll if you're going to take us off the case and tell the state they can't pay us, we'll appear pro bono, because we feel strongly we have a relationship with Richard Allen. He has a right to counsel of his choice, and we believe that's us. And they file an affidavit on behalf of Richard Allen that says, I want Baldwin and Rosie. And the judge denies the motion, will not allow them back on the case. They then have to file a Supreme Court action. Now, it's very unusual to file a Supreme Court action in a case where there's no decision, where it's not, there's been no conviction, there's no judgments. But the Supreme Court agreed to take up the case. So last week, the Supreme Court heard the arguments for, it was a very strange case, because it actually was the lawyer for Judge Gull and the lawyers for Baldwin and Rosie. So Baldwin and Rosie asked to be reinstated. They asked Judge Gull to be disqualified as the judge, and they asked the Supreme Court to order the circuit court to set a trial for Richard Allen within 70 days. Now, one of the issues was that the trial was supposed to be going on right now. The trial was supposed to start in January. They said they were ready, but when Judge Gull took them off the case and appointed new counsel, she set the trial out clear until October. And so they argued in front of the Supreme Court, and in an absolutely stunning move, the Indiana Supreme Court, within 2 hours, issued an order reinstating Baldwin and Rosie. This just never happens. I mean, if you're lucky, a court issues a written decision in a month, but in 2 hours, that it just doesn't happen. But they denied hearing anything having to do with disqualifying Judge Gull or moving the trial date. So Baldwin and Rosie are back on the case, and Richard Allen's very happy about that. But then Judge Gull looks back through the record and looks at all of the motions that now, what she said was, when she took Baldwin and Rosie off the case, she said, I'm not going to consider any of these motions you filed, because they had filed motions, the motion for the Franks hearing, they'd filed motions in limine about the ballistics, they'd filed motions for, there were 3 motions that had to do with, they were pretrial motions. And Judge Gull said, I'm not going to consider any of them. So now that Baldwin and Rosie are back on the case, she issued an decision Monday denying all those motions without hearings. Once again, with no hearing. So what she should have done was held an evidentiary hearing on the Franks motion. She declined to do that, and she declined, just summarily denied all their motions, which I thought was really interesting. So the Supreme Court did not say that Judge Gull could not be disqualified. They said they were not going to make a decision on whether or not she could be disqualified. So Rosie and Baldwin still have the ability to file motions and get Judge Gull disqualified. But for some reason, Judge Gull took that as a validation on her, and she just doubled down. And she did something which is so foolish, to go back and, like, for payback, say, okay, you didn't get rid of me. Now I'm denying all your motions, and you're, too bad, so sad. You don't get to make those motions. So I think it was wrong. I think that it should just about guaranteed that if Richard Allen gets convicted, he gets a new trial. And I think Alan and Rosie are right now, because they've only been back on the case a few days, I think they are right now really looking at their options for refiling the motions on getting rid of Judge Gull and pressing forward on some of the other motions. We've talked in other videos about the fact that the evidence against Richard Allen is very, very thin. I mean, it really boils down to he admitted being in the park and on the bridge that day, and they found a bullet which may have matched the mechanism on his gun. But as we talked about before, ballistics have kind of been discredited as somewhat of a junk science, and particularly when it comes to bullets that have been worked through the mechanism of a gun. When you have a bullet that has actually been fired out of a rifle and you're comparing it to the barrel of the rifle, because every time a bullet goes through the rifle, the barrel of a rifle, it scratches up the barrel. And so the barrel, the markings inside a particular gun will look individualized. So the markings inside a particular gun will depend upon how many rounds have been fired through it, what kind of rounds they were, what size, I mean, there's a myriad of indications. And so then every time a bullet gets fired through that bullet, it leaves those markings on the bullet, on the slug. So when you take a slug that's been fired, it's much more likely that an expert can say this particular bullet was fired out of this particular gun, because the inside of that barrel is almost like a fingerprint. That is not the case when you are talking about an unspent shell and whether it has been worked through the mechanism of a gun, because it's more likely for the gun mechanism to be similar to other guns that are the same model, because that really is the mechanism, the extractor mechanism that pulls the bullet out and puts it in. Those are more likely to be manufactured alike and to leave similar marks on a bullet. So extraction marks are being discredited all over the country. So they filed a motion asking to limit them bringing in the evidence. Now, what should have happened is that there should have been a hearing, and at that hearing, Baldwin and Rosie should have been able to present experts to explain to the judge why that science has been discredited. Now, I was listening, and if you really want to deep dive into Delphi, go listen to Defense Diaries with Bob and Ali Mata. They do a great job, and he is from Illinois, neighboring, so he's got a better handle on some of the legalities. So my understanding from listening to Bob is that they apply a little bit different standard than in the state of Indiana than they do in most states. You don't have a Daubert hearing. Their standards are a little bit different. Nonetheless, what Judge Gall should have done was to hold a hearing, an evidentiary hearing, where she heard evidence about the science and the reliability of that ballistics information. She should not have denied that motion without a hearing. And that is one of the reasons why I think Richard Allen is getting a get out of jail free card. He is going to get a new trial. If he gets convicted in this case, he will get a new trial because of her misconduct. And isn't that sad? All she had to do was follow the law. But she has gotten into this. I'm going to try and use the nicest language I can think of, a pissing contest with his attorneys. And she is absolutely determined that she is the judge and she is going to come out on top. And this is a huge mistake for her. It's a huge mistake for justice, for due process. And it's a huge mistake for her because someone who has this long reputation, she's very well thought of and has this lengthy career in the law, is throwing it all away in a pissing contest with defense attorneys. And it's unnecessary, and it is unprofessional, and all it is going to do is make her look petty, and it's going to win Richard Allen a new trial. And it's unfortunate because now the taxpayers of Indiana are going to be on the hook for a second trial. They're going to try this case. They're going to go through the entire trial. It's going to be a many week trial. And in the end, he's going to appeal. He's going to be granted a new trial, and it's going to be a do-over. And why? I mean, it's foolish. So I think the judge is being short-sighted and foolish in this. And as a result, everybody loses. I think Richard Allen I think that the evidence against Richard Allen, from everything I've seen, is pretty thin. And I think it's very unfortunate that he is being held. He is being held in a prison rather than in pretrial pretrial detention in a jail. And there's ample evidence that he's being mistreated there. I see people in chat saying, my opinion, is guilty. He may be, but guilty people deserve due process, just the same as innocent people. Everybody is entitled to due process. And right now, Richard Allen is not getting due process. And he's not getting it because Judge Fran Gull has gotten into a power struggle with his attorneys. And it is very unfortunate because it doesn't have to be that way and shouldn't be that way. So Judge Gull was recently appointed to be the chief judge in her jurisdiction, which may very well give her an excuse to bow out by saying, I have too many responsibilities. And so, I mean, she may use that as an excuse to bow out of the case. I hope so, because I hope that I hope that she's able to see that she's lost sight of what's important. What's important is making sure that every defendant gets a fair and unbiased decision from a court, and she is not providing that. And I think the most important things judges can do is to take hard looks at themselves and to be self-aware and be one of those people who is able to step back and take a look at their motivations and their beliefs and their biases. And I think in this case, I don't think that she's biased against Richard Allen, but I think she doesn't like Baldwin and Rosie, and she is determined to make life difficult for them. And as a result, Richard Allen is being hurt in the process, and that's just wrong. It is absolutely wrong when a judge or a lawyer cannot set aside their feelings for someone involved in the case and be a professional and try the case. That's a terrible mistake. So I hope that that Baldwin and Rosie are able to keep their cool and to methodically go about showing Judge Gull's bias. And I hope that Judge Gull is a big enough person to look at her own behavior and her own conduct, search her heart, and admit that maybe she isn't as unbiased as she should be, and that maybe she does need to get off the case. And that's going to be very difficult because at this point, she's going to have to admit that she needs to be off the case. And that's hard. I think the state has given her a face-saving out if she says my responsibilities as senior judge or as chief judge don't allow me to be involved in this case anymore. I think they've given her a face-saving out. I hope she takes it. So I guess now we're ready for questions. Yes, there is a Kohberger case on Monday. I'd mentioned that earlier. It is closed at 11 o'clock. And the reason why it's closed at 11 o'clock is because they're going to be talking about grand jury information, and grand juries are kept secret. But there will be an open portion to it. I'm sure at that point, the court is going to consider the prosecution's motion to set a trial in October. I don't think that's going to happen, but I mean, the defense could say, yeah, sure, let's do it this summer. But I doubt it. So, Jenny Pajama Pants, how did you know what I have on? I wonder if John Pryor is panicking because he knows he is going to lose due to Chad being arrogant, believing he'll be found not guilty. Having your client get the death penalty will keep you awake at night. You know, I have no doubt. Frankly, John Pryor is a decent man. Say what you might about his courtroom demeanor. He's bombastic. He's like every other lawyer who came of age in the 80s that I ever worked with. Male attorneys are kind of in that generation. He's very much like a lot of other attorneys his age. But he is a decent human, and he is doing a very hard job. He has established a rapport and a relationship with his client, and he doesn't want to let his client down. That said, it is very difficult sometimes to have those conversations with your client when you're not telling them what they want to hear. Now, I have heard a rumor, and this is only a rumor, that there were some fairly intense plea negotiations and plea discussions going on late last week after Judge Boyce denied the motion for Pryor to withdraw. That would not surprise me at all, because this was sort of a little bit of a last-ditch attempt to get some extra time with more help and more qualified lawyers. I do not doubt for a moment that John Pryor is having a very difficult time getting ready for a death penalty trial alone. It is a big job. And I mean, just having to take the transcript of Lori's hearing and go through it and pick it apart and compare it to witness statements and physical evidence and all of that. I mean, that is going to take him every day, all day from now until the trial starts. So I don't doubt for an instant that he is facing an uphill battle. And I don't doubt for an instant that he could have used some serious help on the case. But I also think that it is really difficult when you have a client who has a mindset that you are unable to shift. And I think that in this case, Chad believes that he is not guilty. I don't know because we don't know the facts, but Chad is not super sophisticated or all that bright from what we can tell. And he is being required to use some pretty advanced kinds of analysis. And right now, what he's saying is, now, I mean, even if you say, okay, Chad, even if he says, I didn't commit the murders, I didn't put my hands on anybody, I didn't end anyone's lives, still, there's ample proof that he was part of the conspiracy. I think it's also, even if he comes out and says, I didn't kill Tammy, Alex did. We know Alex's phone pinged a mile or two up the road in a church parking lot that night. He still opened the door. He still let Alex in. He still was in the house when Tammy died. So it's very difficult to look at all those facts and to see how Pryor is not having any success in explaining to Chad why he's still liable for murder. But it appears at this point that he has not been able to make any headway in any of those plea negotiations. And so I think we're going to have a death penalty trial in April. I sincerely hope I'm wrong, because I think that it will not go well for Chad Daybell. And I think he has the opportunity at this point to settle for something less than the death penalty. But I mean, I have been told that the state has made a non-death penalty offer and has made it on several occasions. I've been told that. I can't confirm that, but that's what I've been told. My own common sense and my own understanding of criminal trials, I would be stunned if they had not. Let's remember that they've already spent probably in excess of $4.5 million to get Lori Vallow convicted. And that is directly on the backs of the taxpayers of little old Fremont County. So the prosecution would very much like to spare the taxpayers another multi-million-dollar trial. But they can't force Chad to take a plea. So if Chad won't take a plea, then they're going to have to try the case. And I think it's looking less and less like he's interested in taking a plea. Some of it, I think, is he's still a true believer. I think he honestly believes that God is going to deliver him from this, that there will be a deliverance, that the end of the world will come, however it happens, and that that God will deliver him. So I think it's unlikely at this point that we're going to see him take a plea. Hi, tennis girl. I just hope Rashbaum doesn't use this to his benefit when things start going badly for his client and cause a mistrial or something. I don't trust him. Well, I think the judge in the case has been very careful to make a very kind of rock solid record of the conflict and of the waivers. And certainly at any point during a trial, a conflict, a non-waivable conflict can arise. That can happen in any trial, not just because Rashbaum previously represented Charlie Adelson. It can happen in any trial. So a mistrial could happen for a conflict, but it wouldn't necessarily be arise out of this waiver. So I don't think that Rashbaum would do that when things started going badly. Only because he has a reputation to maintain beyond the Adelson case. Now, yes, he has become very well known for the Adelson case. However, he's not an older guy. He's a young guy. He's probably got another 20-year career in him. If that's the case, he sure as heck does not want to ruin his reputation for this single case. I used to say, I never want to get so involved in a case and so committed to a case that I would sabotage my own career because I'm going to be practicing law. My reputation is going to be important to me. And I'm going to be practicing law long after these clients, these people on YouTube, all of these people don't remember my name. So I think it's important to remember that. And Dan Rashbaum has a long career in Miami coming up, and it would be really foolish of him to sacrifice that career for the Adelsons. So I don't think we'll see that. Hello, Greg W. Can Dan be called as a witness since he told Donna she could try to get out of town? So I have listened to that call. And I'm not completely convinced that that was what was said. Now, remember, first of all, it's hearsay. Donna's saying what Dan Rashbaum said. But I think if you listen to that recording, what Dan Rashbaum said to her, she said, we're thinking about leaving the country. And what he said was, you might get out, you might not. That's not, I mean, that's not even legal advice, let alone is it get out of town while the getting's good. If you listen to that conversation, what she repeats that sounds like what Dan Rashbaum actually said was, you may get out, but they may arrest you getting on the airplane, which is exactly what happened. So in listening to that, she conflates the two conversations. So she's talking about, we've done this preparation and we're gonna try. She says to her friend, we won't know until we try. But she doesn't say Dan Rashbaum said that. What she says is that Rashbaum told her, you might get out, but you might not. So I'm not convinced that he told her to flee. And yes, he could be called as a witness at Donna's trial. And if he were called as a witness, he would have to step down as a lawyer, and the Tallahassee lawyer would have to take over. So it's possible that he could be called as a witness at Donna's trial. I do not believe that I don't believe that the prosecutor in this case, Georgia, would do that unless she had very strong information that Rashbaum had made that recommendation. And I don't think she has that. I don't believe that she would do that as a tactical move because I think she is too ethical and too good a prosecutor with too good a reputation. So I don't see her doing that and calling him as a witness. And I don't really believe it matters. So the question is, what could Dan Rashbaum add to the conversation? Could they call him and could he say, did you advise them to flee the country? It doesn't really matter, because what matters, what the prosecution wants to bring in, is the consciousness of guilt that caused them to flee. Now, if Georgia has the kind of information that makes Rashbaum a witness for the consciousness of guilt to flee, then maybe. But I just think there's so much there that it's really unnecessary, and it could backfire. You always have to think about what's the downside of calling this witness, not just what can I get out of this witness, but how could that witness hurt my case on cross-examination? So if I had to guess, I would say there is probably a 80 to 90% chance that Georgia would never call Dan Rashbaum as a witness. I just don't think she needs him. She has got the Adelsons in the jetway with one-way tickets to Vietnam. She's got phone conversations and taping about Vietnam not having an extradition treaty. And that information has nothing to do with Dan Rashbaum. In fact, she tries to get Wendy to do the research for her. And Wendy's like, no, not getting involved. Because Wendy knows she's right on the bitter edge. She's on the razor's edge. So yeah, I don't see him calling Dan Rashbaum. They could. And if they did, he would have to get off the case as Donna's attorney. And he mentions it, in that last hearing that he understands the obligation, because that did come up. The judge did bring it up as well about the possibility of him being called as a witness. And he said he understood his responsibilities. He didn't feel that there was a basis for him to be called as a witness. And so, and, you know, to be honest, he probably has already had that conversation with the prosecutor, with Georgia. Just talking to her about, so, you know, let's talk about whether or not you're going to call me as a witness. So, you know, lawyers do that sort of preemptive inoculation, if you will, in their cases. So these are good questions. Hi, Kelly Vieser? Who would hear the hearing to disqualify Fran Gall? Would it be a different judge? So that is a really interesting question. And the bizarre question, the bizarre answer in Indiana, and this is peculiar to Indiana, is Judge Gall. Yeah. In a lot of states, the motion is heard by the chief judge on the bench. And in a lot of states, it is considered, particularly in a case like this, by the Chief Justice of the Supreme Court. So in Murdoch, when Judge Newman recused himself from the case, that appointment of Judge Toll came directly from the Chief Justice, the current Chief Justice of the South Carolina Supreme Court. So, but in that case, my understanding is Judge Gull would make that call. Then Baldwin and Rosie would be free to ask permission to file an interlocutory, that means before the final judgment, appeal. Whether the Supreme Court would hear it now that they've already heard the first part of it, I don't know, but they would be free to do that. The other thing is that every decision that Judge Gall makes is a basis for appeal if Richard Allen gets convicted. So they're going to lean hard on this judge refused to recuse herself, even though we had all this very, very clear indication of bias. So if she refuses to disqualify herself, I think she's just setting them up for more fodder for a new trial. Hi, silly me. If Richard Allen wins the case, then will Gull face any consequence due to her conduct? Well, it's possible she could. When a judge acts in a way that's biased, or if there's question about a judge's um, conduct, there is a judicial fitness board that is overseen by the Chief Justice of the Supreme Court that would review her behavior, and complaints can be filed to that body. So I suspect those complaints have already been filed. If not, they will be. And I suspect that her conduct is going to be reviewed. So there's always a mechanism to review judges and their conduct when it comes to, especially when it comes to specific bias and ethics violations. So it'll be interesting to see how far that goes, because I think that that is going to telegraph just how influential or how much power Judge Gull has within the judiciary. And I think it may not be as much as people think. Hi, Susie Gay. Is it possible with the denials Gull is trying to get her decision on the record and then recuse herself? I think that's possible. I think a lot of people think that that's very possible, that denying those motions, she's putting her position on the record and then she's going to recuse herself. Or at least she's going to say, oh, my new appointment as the chief judge in my jurisdiction means I'm going to be too busy and I can't handle overseeing this case, and allow her to save face and get off the case. I think it's possible. It's hard to say in a tactical way what that looks like, but it could very well be her doubling down like this. I find it kind of surprising. I felt like even though the Supreme Court declined to rule on whether or not she needed to be recused or she needed to be disqualified, I think it was a real slap to her that that the Supreme Court said it was structural error, meaning that it was a constitutional due process violation to take his attorneys, to throw his attorneys off the case. That was a real slap to her, regardless of her them not making a decision on whether or not she was going to be disqualified. It was a slap in the face to her. So it wouldn't surprise me at this point for her to get off the case and to try and save some face at some point. That certainly would be the best outcome for everyone. Hello, blonde granny. I used to be blonde. Now I'm just kind of getting pretty silver. If that was true about Odin cult members, then why did Richard Allen say he was on the bridge that day and admit to his wife and his mom that he was guilty? Good questions. I think that when he told law enforcement he had been on the bridge that day, he felt he had nothing to hide because he was not responsible. His attorneys claim that the reason he admitted on the telephone that to his guilt was because he was being threatened by the guards who were overseeing his security in the prison, the Odinist guards. His attorneys contend that they were threatening him, that they were telling him that the Odinists on the outside would be looking for his family, for his wife and his daughter, that they were at risk. And in fact, they point to the fact that the first time he was able to talk to his wife, the first thing he asked was, "Are you okay? Are you safe?" So it was clear that he felt there was some sort of a threat to his family. I mean, that is once again going to be he said, said kind of an argument, but the fact that these officers were, that there's some ample evidence that they were being abusive to him, kind of points in that direction. So I think it's enough to raise doubt. Hi-lo, Eileen Santu. What about the video? Could it identify RA? Now, we have not seen, the only thing we have ever seen is that tiny little snippet where he says, "Guys down the hill." We have not seen the rest of that video. So that is a good question. Everyone who has analyzed that video has said it is impossible to either rule him in or rule him out. And everybody who sees that video sees something different or sees someone different. It has not been possible for them to voice analyze it or to do any analysis that we know of, at least, that would identify him as the person who forced them off the bridge and down the hill. So I mean, I think that video has been analyzed 17 ways from Sunday, and we have not heard anything from either side that would indicate that they are able to, with any certainty, say that's Richard Allen. And in fact, when the witnesses that were there in the park that day did sketches, there's more than one sketch that actually looks like different people. So we don't know whether those were people that somebody just happened to see in the park and thought were suspicious. We don't know whether or not those were actually Libby and Abby's murderers. We don't know. But we do know that the sketch artists initially captured some images that look very, very different from one another. Hi, Tonya. I'm late, so apologize if this has been asked. Will you be watching the trial of the parents of the Oxford shooter? Jennifer starts tomorrow with opening statements. I didn't realize it started that soon, but I will be watching it because I am really interested in this particular case. You all know that I'm a retired criminal attorney, that most of my career I did public defense work, represented clients, adult and juvenile clients, and represented a variety of charges from misdemeanors all the way up through everything just short of capital cases. I represented attempted murder cases, robbery, violent crimes. So, but the last 5 years of my career was pretty much exclusive. I was pretty much exclusively doing juvenile work. I did both juvenile delinquency, kids that have violated the law, as well as juvenile dependency, meaning kids that have been removed from their families for child welfare cases. So I did a couple of pretty gnarly juvenile delinquency cases with kids. One of them was an attempted murder case, where the juvenile was accused of having attempted to murder his mother. And the issue of juvenile justice and when we hold juveniles, what way we hold juveniles accountable, at what age we hold them to adult consequences, and when do we hold parents liable for their children's actions? This really fascinates me because it is really what we lawyers call a case of first impression, meaning that there are no other cases out there that have previously held a school shooter's parents responsible for his actions. I think that his parents' actions were particularly egregious, but the question is going to be, can we hold an adult parent responsible for their minor child's actions? And that really interests me because, as I say, it's a case of first impression. So I will be watching it, and I'm looking forward to hearing the closing arguments on Friday. For some reason, I thought it was still a couple of weeks out, but so I'm glad you gave me a heads up. Hi, Carly Fontana. Curious if you would ever go over the Bob Menendez case. Curious whether his asking for the items found in the search of his home to be kept out is anything that is possible. I'm not familiar with that case. I'm going to write it down, and I will look into it. Because if there were things that were found in a search of his home and there was a valid warrant for it, or were things that were found in plain sight while he was being arrested, that would be something to look into. So if he's saying these things that were seized in my house were seized illegally, and so anything that comes in related to them is fruit of the poisonous tree, that's a different argument. It would be difficult for him to keep out things that were legally seized, either incident to his arrest or incident to a search warrant. But I'm not that familiar, and I'm going to look it up, and I will answer your question. I'm writing a note to myself so that I will remember what you asked. Hey, tennis girl, what would you have advised Donna Adelson regarding her desire to possibly leave the country? Well, I think, interestingly, Dan Roshbaum, in his interview with Joel Waldman, makes the point that at the time that Donna was contemplating leaving, there was no prohibition on her leaving. It wasn't illegal. So he wasn't advising his client to break the law. That is true. I think I would have been cautious about talking about that. And I think I would have said to my clients, if you decide to leave the country, be prepared, because this isn't over. Don't be naive enough to think that you leave the country and it's all going to go away, because it isn't. And leaving the country is not going to solve the issue. Because yes, Vietnam may not, or some other country that you might flee to might not have an extradition treaty. However, the US government doesn't give up trying to get people back. As an example, recently, let me see if I can dredge up the case, but there was recently a case where someone was brought back from a country, and one of the stipulations on the extradition was that that person could not be subjected to life in prison without parole, because the country that they were coming from does not believe in that. And the US government agreed and said, we will not seek life without parole. So the US government has been known to negotiate the charges on our end in order to get the person back from a foreign country. If I had been Dan Roshbaum, I would have advised my client to be very cautious about trying to leave the country, because fleeing indicates consciousness of guilt. So I would have advised her of those things. Would I have said leave or don't leave? No, because that's not my place. I would have advised her what the consequences might be if she decided to go, because that is my place. But to say, go ahead and try it, I mean, I don't think Dan Roshbaum said that. I think he said exactly what I would have said. You might make it, but you might not. I think then Donna Adelson in that conversation conflated what he was saying with what she was saying to her friend, which was, it's worth a try. But I don't think Dan Roshbaum ever said that. So could be wrong. Any updates, movement on the Karen Reed case? You know, I didn't go into the Karen Reed case tonight. It is still, and I really do need to do a deep dive into it because it is so interesting. Karen Reed case, it is so wrapped up in Boston politics, Boston law enforcement, the possibility of corruption within the Boston law enforcement community, the fact that they may be keeping, trying to keep protecting fellow officers, all of those things. I did hear today that they had gone back and gotten a search warrant to seize her telephone to find out whether or not she has had communication with the YouTube creator called Turtle Boy, because he's been accused of attempting to tamper with witnesses. And so that's really interesting because they're trying to find out whether or not she has connection with him and connecting her to any kind of attempted witness tampering. I don't know what the outcome will be of that, but I thought it was kind of interesting. They are definitely not giving up on Karen Reed. And I do need to do a more of an in-depth look at that. There are some people who have been doing really in-depth looks at it, including Brandy Cresswell, whose channel is called The 13th Juror. And she's been doing quite deep dives into that case, into Karen Reed. Hi, Mary. Actually, the prosecutor and the sheriff admitted it. I'm sorry, the question is there proof that the guards have these Odin patches on their uniforms? Is that allowed? It was allowed, and there is a statement from the sheriff saying that guards were permitted to personalize their uniforms, and that it was allowed, and they have since directed the guards to take the patches off. But the sheriff, in fact, did admit that there were guards wearing those patches, that they were allowed to personalize their uniforms, and that they have been directed to take them off. So it was confirmed by the sheriff and the prosecutor themselves that it happened. Good question. Hi, Ladybug Lady. Hope your ladybugs are staying warm these days. If Daybell does not have a mitigation specialist, will he be able to file ineffective counsel even though he has a private attorney? Good question. And I think the answer, if he doesn't hire a mitigation specialist, is no. For one thing, we now have a record of the judge having held some sort of an inquiry with Pryor about whether or not he has a mitigation specialist. And we have some evidence on the record of the judge acknowledging that Pryor is not bound by the ABA best practices the way that court-appointed, state-paid court-appointed attorneys are. Now, what would be really interesting is the judge has not, back a year ago in January, when the judge was told that Chad Daybell was indigent, he authorized John Pryor to find a death penalty qualified attorney and to hire that person at state expense. So kind of a hybrid of court-appointed and retained counsel. It's very unusual and sort of goes against the state guidelines, but the judge approved that. John Pryor has never been able to find an attorney who would come on at the state rate as the death penalty qualified attorney to help and advise. The interesting question is, if he were able to find somebody to come on as a death penalty qualified, being paid by the state, would that attorney be required to follow the state requirement to follow the ABA best practices for death penalty cases? Interesting question. As it stands right now, I don't believe that not hiring a mitigation specialist would be ineffective counsel. That ineffective counsel really turns on what the lawyer does at trial. So if John Pryor is able to put on an effective mitigation case without a mitigation specialist, then I don't think he gets to ineffective counsel. But it's an interesting question to wonder whether would be required to hire one if he hires a state-paid death penalty qualified attorney. So interesting things to think about. Hi, Becky Ireland. There will be an audio version of my book. Whether I am invited to read it or not is completely up to my publisher. And typically, authors don't read their books. Occasionally, especially if they're popular or have big followings or are radio personalities or, those sort of things. Hi, Carrie. How do I get an autographed copy of Children of Darkness and Light? I am working out all of those details right now, and you will have links and you will be able to order autographed copies. You will be able to pre-order copies, and all of that information will be coming out in May. And the pre-order link will go hot for CRIMECON. And CRIMECON is the 30th of May through the 1st of June. Which reminds me, for anybody who's thinking about going to CRIMECON, you can get a little bit of an entry and a little bit of a break on tickets, because I know tickets are steep. A ticket for the whole weekend, they're expensive. But you can volunteer at CRIMECON and direct traffic and do those sorts of things, and you get a ticket in return. So there is a link in our show notes to where you go if you want to be a CRIMECON volunteer. And CRIMECON is happening in Nashville, Tennessee, May 30th through June 1st. We'll be there. We're going to have a booth. We're going to be handing out swag. We're going to be talking to folks. We're going to be inviting people to pre-order the book and just in general celebrating its launch. So, and you absolutely will be able to order autographed copies. It's exciting to think that somebody wants an autographed copy of my book. I'm super excited about that. So thanks for asking. Let's see if we have a couple more questions and we'll wrap up for tonight. Hi, Charlotte. Lori, have you followed the UK post office scandal? I'd love to see a US lawyer cover it. I've heard a little bit about it, but I haven't looked into it enough to really comment intelligently. But I would love to look into it if you all are interested in it. So let me know in the comments if you're interested in hearing what I have to say. I will point out that American and English jurisprudence are quite different. Even though our common law is based on the British system, we also have a constitution that governs how our law is applied. And in England, they're much more driven by the centuries of history and British common law. I'm not an expert on British law, so but I could give you my take from a US standpoint, and I'd be happy to do that. I have heard a little bit about it. People were accused of trafficking in drugs through the post office I think, and were arrested, convicted, and then, oh, no, I'm sorry. They were accused of having, they were postal employees who were accused of having stolen money from the post office. And as it turned out to be an accounting issue and not theft. And a lot of them were wrongfully accused and wrongfully imprisoned. And in an organization similar to the Innocence Project, they were finally exonerated. And so now a lot of them have claims against the government for wrongful imprisonment. So really interesting case, and I will look into it, and I'll give you my thoughts on it. Oh, any thoughts on Scott Peterson and the Innocence Project news? Oh, I'd forgotten about this one, but I'm glad you brought it up. Thanks, Jane. I think this will be our last question, and I think it's very interesting. The National Innocence Project, the project that began it all, is sort of the umbrella organization for many individual organizations. So every state has an Innocence Project, and a lot of counties have Innocence Projects. And each one of those is overseen differently. And each one of those determines what sort of cases they will take and not take. So it wasn't very long after it was announced that the Los Angeles Innocence Project, which is an independent organization, was going to look into Scott Peterson's case, that the national umbrella organization came out and said, hang on, we did not make that decision. That is a decision solely made by that individual, discrete Los Angeles Innocence Project, and doesn't reflect how the overall Innocence Project determines what cases they're going to take. The Innocence Project in the past has limited their acceptance of cases to cases where DNA can clearly exonerate someone. They have begun to branch out and perhaps look at other cases, but they always are very focused on scientific evidence being able to exonerate someone. Now, in the Scott Peterson case, my understanding is there was a robbery that happened across the street on the day that Laci Peterson went missing. And there has always been a question whether or not she interrupted this robbery. And there was a van, the getaway van, which they burned. They are asking that van, that the evidence gathered from that van be retested to find out whether or not Laci's DNA is in the getaway van from the robbery across the street, because they feel that would corroborate some stories from a lady walking her dog and some other people on the street that were sort of discounted in the investigation. Do I think Scott Peterson is going to be exonerated? I doubt it. But they have taken it up and have asked for a retesting of some of that physical evidence that was found in the van that was abandoned by and burned by the robbers. So I don't know. I doubt that Scott Peterson is going to get exonerated as a result, but his family has always claimed his innocence. He has always claimed his innocence. And in fact, recently, his death penalty, the death penalty was commuted to life in prison. So he's still in there swinging, still in there fighting. And, I mean, I think every defendant is entitled to exhaust every opportunity to exonerate themselves, especially in death penalty cases. So great questions tonight, folks. You've been wonderful, as usual. I always look forward to our Wednesday nights. So I want to just say thanks. Thanks for being here. Thanks for joining us. We've had almost 400 people in the chat as the evening has gone on. And I appreciate you spending your Wednesday night with me. I appreciate that you all have such interesting comments and chat, that this is a great community. And I appreciate that you spend Wednesday night with me every week. I want to say thank you again. I will see you next week on Wednesday, unless there's something super exciting that happens, and then we'll do a surprise live. But for now, I'll see you next week. Have a great week. Good night.